So in certain segments it's very clear. If you have a charge there, when the charge is there, then it is completely clear that that right arises. But the court has said, and the best definition of that is in Simeonovi case, I would say. The court has said that that from the point at which the situation has been substantially affected by actions, the situation of the accused, of the person has been substantially affected by actions taken by the authorities as a result of a suspicion against that person, then that person gets the right. What that means? That means when the questioning starts, regardless whether the person has been arrested or not, but the questioning starts. That is the case of the fourth guy in Ibrahim case. Or when the person is arrested or is put in detention, regardless whether the questioning has started or not. The mere fact that it is arrested is sufficient, so you see. No? Or, for example, when some other investigative measures have been taken, like reconstruction or line up. Our case law says whichever occurs first, then the right attaches. Of course, that doesn't mean that if the lawyer is not provided, that there will be automatically violation. No? There should be some prejudice related to that. But this is how it is defined, from which moment the person has the right of access to a lawyer. Since you didn't have questions, I would like to tell you one thing, or two things. First, there is one very interesting paragraph in verse. This is paragraph 147, which says, lastly, it must be pointed out that the principle of placing the overall fairness of the proceedings at the heart of the assessment is not limited to the right of access to a lawyer under Article 6.3, but is inherent in the broader case law on defense rights enshrined in Article 6.1 of the Convention. And you could see how slowly, under the pretext that this is something that existed in the Convention from the beginning, overall fairness test is sneaking in Article 6. And I would say dangerously. Why? It entered in first in Saakashvili and then in Ibrahim. And both we could say is fine. Why? Because in both of these cases, the court was dealing with issues related to pre-trial proceedings. And then you say, we are looking at the trial as a whole, because whatever has been done in pre-trial proceedings could be remedied during the trial. Not always, but could be. So it makes sense to look at the trial as a whole. But once we are at the trial level, we have to ask ourselves what that means. And Ibrahim said expressly, we are making this rule for pre-trial proceedings. Ibrahim said that expressly, but the judges are forgetting that. And we recently had an Armenian case 2 weeks ago related to expert witnesses. The case didn't say anything about that, but the jury's counsel, writing a note, posed the question, how that would look and how we compare pre-trial and trial. I must say Supreme Court makes a big difference between these two things. We made a big difference between these two things. So it's really interesting, in which way the court would go, because that could mean that we could balance out the rights of the suspect completely. That could mean, and we can see a tendency when the cases are analyzed, that the outcome somehow determines the way how we think about that, and it shouldn't, ever shouldn't, it should be always only procedural rule. So this is one thing that I wanted to say, and we will see how the court will proceed. The other thing that seems interesting for you, to me, seems interesting to you, what theirs means at the national level for legislators. What does it mean for police, prosecutor, investigative judge? What does it mean for ordinary courts? And what does it mean for the Constitutional Court? So when we are looking at the legislator, it means what we have said there somewhere on that slide. This is for the legislator. Sorry. Exceptional circumstances must be of temporary nature, individual assessment. Domestic law has to prescribe that, very precise. What are compelling reasons? And compelling reasons, one we have given, the other one you can find in the directive. So this is legislature. What that means for the police? Could police think and apply things that are not there on the terms of overall fairness? Of course not. Basically, overall fairness, our court invented for itself. How we would look at the cases when they will come to us. Of course, that would have spillover effect for the national authorities. But not, it shouldn't have for police, prosecutors, and the guys who are deciding. They should just look whether there are compelling reasons or not, and when there are compelling reasons they can apply, when there are not compelling reasons they cannot apply. If compelling reasons are not prescribed at the domestic level, then you are looking what exists in the convention. You are not in the EU, so you cannot look at the directive, but you can try. We would never say that that's something against. And then ordinary courts, depends whether this is an appeal. If it is an appeal, then you are using that as a standard, whether everything was done fine. And there's a constitutional court as well. So thank you very much.
Дуже дякую за вашу доповідь. Тут у нас, на жаль, немає часу зараз на наступні запитання. Я думаю, що ми можемо перейти до наступної доповіді, але до того, як суддя Раварані приступить до цієї доповіді, я хотів би сказати, що дійсно з точки зору виконання рішень Європейського суду з прав людини і практичної імплементації рішень, які стосуються права на правову допомогу, може виникнути певні проблеми з точки зору формулювання того, що ж має на підставі цього рішення тепер вжити, які заходи має вжити держава індивідуального і загального характеру на виконання вимог практики Європейського суду з прав людини в широкому сенсі. Зокрема, якщо звернути увагу на ті справи, в яких Європейський суд постановлятиме рішення стосовно відсутності належного забезпечення права на правову допомогу на початкових стадіях процесу, то дійсно може виникнути питання, що ж мають робити національні суди, яким чином вони мають переглядати попередні рішення, свої попередні рішення на підставі рішень Європейського суду і відповідно на яку стадію процесу необхідно повертатися. І що саме треба переглядати. Тобто тут дуже багато проблем виникає як з точки зору процесуального законодавства, так і матеріального наповнення наступних рішень на підставі рішень, в тому числі Європейського суду з прав людини. Прошу, пан Раварані, ви наступний наш спікер. Я хотів би трошки декілька слів сказати про вас. Суддя Раварані, суддя від Люксембургу. Він був суддєю в національній правовій системі Люксембургу, але також займався академічною роботою і отримав ступінь магістра права в університеті Гренобля в 1977 році, але також захистив докторську дисертацію, яка стосувалася в 2011 році, яка стосувалася питань цивільної відповідальності органів державної влади за законодавством Люксембурга. Я прошу вас до трибуни І дійсно тематика дуже цікава. Тематика, яка стосується положень національного законодавства, і є дуже жвава дискусія в національному правовому полі, зокрема з точки зору принципу, про який буде говорити суддя Раварані, принципу non-bis in idem, який в принципі викладено в статті 61 Конституції України. Цей принцип також з точки зору академічної дискусії має певний резонанс з точки зору статті 7 Кримінального кодексу України. Тому дуже цікаво буде почути співвідношення якраз цих положень національного законодавства, Конституції України і Кримінального кодексу і положень практики Європейського суду з прав людини. Дякую. Прошу.
Thank you, Mr. President. Ladies and gentlemen, I was told that Ukrainians are very smart and tough people. I'm prepared to believe that, but now we will have an opportunity to assess that, because it's the end of a very long day, an intense day, and all our brains are full with human rights talks. You will unfortunately have to deal with a dinosaur, no pictures at all, you will have to listen to me. And finally, the topic is very, very technical. So after the following 30 minutes, you will probably say never again. We wouldn't like to endure this twice, and that's exactly the topic I will address now, the non-bis in idem, not twice the same. Let me start with an example. A surgeon is prosecuted and convicted in a criminal court for the accidental death of a patient resulting from medical negligence. He is sentenced to a suspended prison sentence and a fine. 6 months later, the competent administrative authority decides, based on the criminal judgment, to deprive him of his medical license. Well, the surgeon claims then that he has been treated unfairly, and more precisely, that he has been punished twice on the same facts. The authorities will repeat, no, there has been only one criminal conviction, the other one is an administrative one. Well, he can possibly avail himself of a straightforward and easily understandable rule which is summed up in a formula since centuries even in Latin, ne or non bis in idem, which simply means not twice the same. Well, nobody should be punished twice for the same crime. And I learn now that it is in the Ukrainian constitution and in the criminal code, which is very smart again. Well, this is an essential safeguard against state abuse, and it's therefore all the more astonishing that it hadn't been included in the original convention. Many states were reluctant to accept such a rule because they wanted to deal on an administrative basis with some technical issues, for instance, tax and financial matters, where they wanted to have that on the administrative side. And in some sense, that is good, because I prefer to be sanctioned on an administrative basis than to have it criminalized immediately. Still, the rule in itself is extremely important, and it was eventually incorporated in the convention by Protocol 7, Article 4, which entered into force in 1988. And it has been elevated to, this morning we spoke about derogable rights. This is one of the rare underogable rights. So, under Article 15, even if the life of the nation is threatened or if there's war, this right is so important that there is no derogation possible. However, although fundamental, the precise wording of the rule shows that things are not that easy. And I quote the protocol, paragraph 1 of Article 4 of Protocol 7, no one shall be liable to be tried or punished again in criminal proceedings under the jurisdiction of the same state for an offense for which he has already been finally acquitted or convicted in accordance with the law and penal procedure of that state. Very complicated. So, such careful wording demonstrates that in reality it is quite difficult to clearly draw the limits of the rule, in other words, the scope of it and the mechanism of it. And therefore, in two parts, I will first address the scope of the rule and afterwards the precise functioning, the mechanism of the rule. As to the scope of the rule, first, the rule only applies in criminal proceedings. So, in my aforementioned example, there should be no difficulty given that there have been two kinds of proceedings, a criminal one and afterwards an administrative one. Well, sticking to that would be extremely easy for states to escape the rule by simply qualifying some proceedings as penalties, as administrative penalties, and consequently non-criminal penalties. The court, the Strasbourg court, has held that the notion of criminal procedure and criminal facts have to be interpreted in an autonomous way in the light of the general principles corresponding to words of criminal charge and penalty in Articles 6 and 7 of the Convention. So, the court's established case law sets out the very famous criteria that I will not go into the criteria. It's the Engel criteria which have been fixed in a very early judgment of the court in 1976 already. Let me just say that it's more or less the degree of severity of a penalty which is tending to qualify it as criminal, even if the national law tends to qualify it as of only administrative nature. If it is really severe, then the court tends to call it criminal. A typical example of proceedings that are not necessarily qualified as criminal in domestic law, but may end up being qualified as being of such nature, are disciplinary proceedings and sanctions directed against civil servants, judges, for instance, or members of some regulated professions, lawyers, architects, and so on. So the severity of the offense can entail the criminal qualification despite the fact that the national law keeps it on the administrative level. We have the same with tax surcharges. If you are fined with very heavy surtax because you didn't make an accurate declaration, this could be considered as criminal by the court, whereas the national authorities would qualify it as administrative. The same with driving license. The withdrawal of a driving license, when it is too heavy, well, if it is too long, and if it is really aimed at punishing somebody more than the driving license, it's interesting. Driving license can be withdrawn as a punishment, but you can also see it as preventing further damage for the public. So there the purpose of the rule comes into play. If you say that withdrawing the driving license from somebody is aimed mainly at punishing him, then you will say, well, it's a criminal conviction. But if you say, no, we want to save the public from this mad driver, then it can be administrative and not criminal, because the purpose of the rule is not to punish, but to prevent the public from further damage. In a very recent case of last week, a Croatian case about hooliganism, there was a rule about a ban to attend football matches in the future. And it was very difficult to assess whether that was a penalty or whether that was an administrative measure. Well, the court, very often there are overlaps. it is as well punishment as also prevention. Then you have to look at the predominant purpose. And in this hooliganism issue, the court ultimately found, it had very long reasoning, but it ultimately found that it was especially to protect the public of football matches from potential violence more than a punishment, which entailed that it was only an administrative measure. The thing is that this man had previously been punished for some violence, but then this punishment was added, and therefore there was the problem whether there was a non-bis, a bis in idem. Well, it was said that this is not of criminal nature, and therefore it could be added to previous convictions. Secondly, this rule just only applies to national authorities. If somebody has been convicted or acquitted abroad, this doesn't count for the Protocol 7 Article 4. It's only if a national court sentences or comes to a second proceeding that it is relevant. This differentiates the rule from the EU Charter of Human Rights, because the EU has a wider scope. It prevents a punishment or even proceedings, criminal proceedings, if in another EU country there has already been a final acquittal or punishment. Another small issue, the rule does not forbid reopening of proceedings if there are newly discovered facts or new facts and that is what normally is called revision in many states. So the revision is possible if there is the discovery of new facts. This is in paragraph 2 of Article 4 of Protocol 7, but that's not the main purpose of the intervention of today. So this is about the scope. I now come to the mechanism of the rule. The formula, non bis in idem, is very short, but it encompasses two separate requirements. For the rule to apply, there must be the idem, that's to say the same offense, and the bis, that says the two separate proceedings for the same offense. So first, the same offense. The same offense requirement has led to real difficulties for the court to find its way. There are basically two ways to characterize the identity of an offense. The emphasis is either on the mere facts that give rise to the prosecution or on their legal characterization. Should prohibition apply whatever the second legal characterization is, provided that the facts upon the second prosecution rise are the same, or can there be a second prosecution and conviction if the same facts respond to different legal characterizations? During the first period, the court accepted that the different legal characteristics enabled a second prosecution. But then, responding to criticism about this approach, there was an important grand chamber judgment by the court, which you probably know, Solotukin versus Russia of 2009, which radically established a quite straightforward rule and saying that the same facts are the criterion for saying if there is the same offense. It was a case about a military who had been fined in a minor offenses issue, and he was also fined by an administrative penalty. And he claimed, well, it was about the same facts, and then the court accepted that and said it's the same facts, so you cannot qualify differently the same facts, and the legal characterization is irrelevant if it's exactly the same facts. But this revealed itself, and I was an administrative judge for more than 20 years, this revealed itself catastrophic for administrative authorities and courts, because henceforth it was no more possible to impose an administrative sanction upon somebody who had been criminally convicted or acquitted for the same facts. Returning to the introductory example of the surgeon, the surgeon had been criminally convicted and no ban on going on to exercise professionally had been pronounced. When then the administrative sanction comes the second time on exactly the same facts, you can't prevent it, which is, of course, very dangerous because he has been fined or even convicted even to a prison sentence because he is a dangerous man. And then you let him go on exercise his profession. But that was the risk by Solotuki. There were heavy criticism against that judgment and the court reacted. In 2016, another grand chamber judgment, A and B versus Norway, adopted a more flexible approach. It was what was commonly called mixed procedures. That's to say, criminal procedures followed by administrative ones and vice versa. Well, I come to the notion when addressing the second aspect, the B's, the two proceedings. Let's be precise. The aim of Article 4 of Protocol 7 is to prohibit the repetition of criminal proceedings that have been concluded by a final decision. The criterion applicable is that of res judicata. That is the case when all ordinary remedies available have been exhausted. The emphasis on the ordinary remedies is important because, as mentioned before, the possibility of extraordinary remedies does not prevent the rule from operating. It should be stressed once more that the non bis in idem or ne bis in idem guarantee extends not only to subsequent convictions but also to subsequent prosecutions. This is sometimes not very much regarded. It's not only convictions but it's also prosecutions. First, then, a new prosecution, not even a conviction, but even a prosecution is prohibited after a final conviction or acquittal for the same facts. Moreover, in case of parallel proceedings, administrative and criminal one, a final decision is reached in one, the second one has to be discontinued. Many states have a rule of suspension when the criminal proceedings are on their way. Normally the administrative have to be suspended, but it's not a rule in all countries. Another very important issue is to know what really a final decision is. And we are actually at the court, we have to deal with the case, it's an easy case, but the issue is very difficult. It was about prosecution. In Croatia, a man was arrested he was stopped to undergo a blood test. He refused the blood test. Then he was fined on an administrative basis by the prosecutor. He had a fine by the prosecutor for refusing to undergo the blood test. And he had 20 days to appeal, but he let the 20 days expire and he paid the fine. He thought the story was over, but the superior prosecutor annulled then the administrative fine and prosecuted him criminally, and he was then criminally convicted. And then he said, well, this is two prosecutions. But the prosecutor said, well, the first one was not a final decision. And then you don't know when a prosecutor discontinues prosecution, can that amount to a final decision? Normally, a prosecutor can discontinue and reopen proceedings. What if he has done it on a very thorough reasoning with a reasoned decision? That's the problem. And that's the problem we have to deal actually. If the discontinuation is not simply to put it aside and to take it out of the cupboard, if the decision to reinstate is taken after a thorough reasoning, in some countries even by a judicial decision. In Belgium you can have a judgment saying we discontinue the proceedings because the charges are not high enough. Can you then reinstate them? This is a judgment which is under consideration and which will be issued on a later stage. What it is about is whether, when the superior prosecutor annuls the decision of the lower prosecutor and then reinstates proceedings, if that is not a violation of the famous non bis in idem rule. So, just to come to the car driving, to the car driving context, the court found that the imposition of a fine by a criminal judge and the subsequent administrative withdrawal of the driving license for the same facts, the excessive speed, did not violate the non bis in idem rule. It held that a substantial temporal and close link between the two proceedings gave rise to a unique system with two aspects and not to two separate proceedings. And I come now to the A and P versus Norway case. There, the court, it had to reinvent the ne bis in idem, and it had to depart from the same fact problem. And then it it forged the central notion of close connections between various proceedings. It examined the Norwegian system, and in the Norwegian system, this meant these two persons who had claimed that they had been convicted twice, they had made wrong tax declaration.